Are all adverse actions by employers grounds for retaliation claims? Recent discussions in the labor and employment law field have raised an important question. Are all adverse actions by employers grounds for retaliation claims? This topic is particularly relevant as employees and employers navigate workplace rights and responsibilities. Many people are searching for clarity on what constitutes retaliation in the workplace. To start, not every negative action taken by an employer qualifies as retaliation. Retaliation claims must show a connection between the adverse action and the employee's protected activity. This means that if an employee reports discrimination or participates in an investigation and then faces negative consequences, they may have grounds for a retaliation claim. Retaliation occurs when an employer takes a negative action against an employee because the employee engaged in a legally protected activity. Such actions can include termination, demotion, or harassment. For a retaliation claim to hold up, the employee must have engaged in a protected activity recognized by law. This could involve whistleblowing, requesting accommodations under the Americans with Disabilities Act, or complaining about unlawful conduct. It is essential to establish that the adverse action is causally linked to the protected activity. If an employer can demonstrate that the action was based on legitimate reasons, such as poor performance or company restructuring, the claim may not succeed. Examples of retaliatory actions include intimidation, threats, demotion, and denial of benefits. These actions often follow an employee exercising their rights. However, not all adverse actions are retaliatory. Some may be routine employment decisions made for lawful reasons. For instance, failure to renew a contract or denial of a transfer may not be considered retaliation if they are not connected to a protected complaint. Legal protections exist under various laws that prohibit retaliation. Employees must often show reasonable cause to believe their protected activity triggered the adverse action. Understanding these nuances is vital for both employees and employers. In short, an adverse action by an employer supports a retaliation claim only if it is connected to the employee's protected activity. Routine or lawful employment decisions without such a connection do not constitute retaliation under labor and employment law.